So which one of these? Yeah, sorry, 10 minutes. I'm just looking at your thing there. As I said, I had you at 10 past on my end. Attachments to read. Here we go. Now, are these in a particular order?
No.
Okay.
Yeah, that's just the back of a letter. So that's the second page of a letter council sent out regarding changing categories.
And what was the category they're changing you from or to?
Well, see, I'm on acreage and we've always been rural residential, and they've changed us to residential, but still apparently got zoning for rural. But what they've done is they've added a base fee, a residential base fee, and also percentage of our rateable value.
All right. I don't need to look too much at this, and I can tell you exactly what's going on here, Kim. And it's quite dodgy, and this has been happening to a few places that are living in rural areas. Are you on like whereabouts exactly are you, Kim?
Buxton, New South Wales. Have you heard of Picton?
Yep.
Yeah, not far from Picton. We're not far from Nadine National Park.
Yeah. What's happening with a lot of these areas is the councils are looking at getting ready for future developments, 15-minute cities, etc.
Yeah, that's what I've sort of heard.
And what they've been doing, Kim, is they've been going around to these rural areas that were rural and listing them as residential. And I'm going to make an educated guess here that in the next 6 to 12 months, you will get a visit from someone at council offering to buy your property from you.
Right.
And saying it's now residential, and that what they've done with a few farmers, and these guys have been forced to sell up and move, is they've said, look, you're on 100 acres. We can fit 400 quarter-acre houses on there. So what we're going to do is we're going to make your rates to the equivalent of the 400 houses due to our loss of income claim.
Yeah.
What we could be getting off if we put quarter-acre blocks on your property, we could levy the rates to be much more for the council. And if you don't agree to this, we will change, because you've now listed as a residential area, where you're going to change your rates to per quarter-acre per house, unless you sell to us at an agreed upon rate. So any of the people who are living on those semi-rural areas that are getting this sort of change of zoning, this is a prelude to what's to come. I hate to be the bearer of bad news, but we've been seeing this happen across the country for the last year or two.
Yeah. Have you got a specific area that it's actually happening to?
It's been happening in Victoria, down around Keysborough. There was a farmer there who was on the outskirts of the suburb, and the council came and done that to him and wanted to levy the rates. Now, what you've got to let the council know, Kim, is that at no point in time have you agreed to the changes of your agreement or contract with the council as far as the rates to which you're obligated to pay.
I have. They fobbed me off.
And you've let them know that you're not agreeable to the changes.
Yeah.
Have you also reminded them that under contract law, it is prohibited to make changes or amendments to an agreement or a contract without the consent of both parties entering into that contract?
Sort of along those lines, another person who's along the lines with me, we went to a meeting with them, and she knows how to talk about the Constitution and how they're not actually a local government. They don't actually have the rights to be doing what they're doing. And they just sort of laughed us off. They don't really care.
All right. So instead of making statements and claims, Ken, what we need to be doing is asking questions. So when you go to this council meeting, ask them some of these following questions. One, can they provide any evidence that unequivocally proves or supports their claim of legitimacy as a legitimate tier of government? As it stands, we only have two legitimate tiers of government in Australia, which are state and federal.
Yeah.
Now, the state and the federal, our state governments and the parliaments get their powers to make laws from the Constitution, specifically Section 51, which is where the lawmaking powers of the states and the parliaments of the states are derived from. It's derived from the Constitution under Section 51, which very clearly states, and the councils, when they read this out, they'll go, no. If you have a look at Section 51, it says that the states parliaments of have the power to make laws for the peace and good governance of the people, which is what's occurred. But somehow no one at council is able to read the first 4 words of that sentence, which says subject to this Constitution.
Yeah, we've basically done that at the meeting. That's exactly what Jenny asked, provide us with any evidence of that. Exactly what you're saying. She even put it in letter form and handed it to them, and they never responded to us. Like the lady.
So what's happened is we've had 2 failed referendums over the years in attempts to change or alter the Constitution to recognise the legitimacy of local council as a further 3rd tier of government.
Yeah.
Both referendums failed. Therefore, what's happened then is the states have gone and passed law, courtesy of Section 51, that was actually done not subject to the Constitution. Because after the failed referendum and the Constitution not recognising local council's legitimacy, the states then went and passed their own law, contrary to the Constitution, granting local councils the ability to act as some form of tier of government. Now, Section 109 of our Constitution expressly prohibits such actions. 109, Kim, is just one sentence. And it says that when the laws of a state are in conflict with that of the Commonwealth, that the latter shall prevail and the former shall, to the extent of its inconsistency, be invalid. Now, the inconsistency we're drawing our attention to is the claim of a legitimate tier of government from a local council, despite the fact the Constitution doesn't recognise them as such, pursuant to 2 failed referendums and Section 109, which renders the state law granting them such powers invalid due to their inconsistency with that of the Constitution of the Commonwealth of Australia of 1901. Now, as far as the extra levy on your rates and the change in zoning, when were you notified of that?
Well, they reckon they sent everybody a letter back in, I'll just get to it because I never got it, on the 31st of March 2023.
They may have sent a letter to everybody informing them of the change of that and asking for submissions or objections or recommendations. Unless they have proof of receipt of service that you actually received that, full discovery and disclosure was not provided to you, allowing them the provision to amend or alter the terms of an agreement or contract in the absence of consent.
Yeah.
So what no, is you've added this additional base rate. We're not agreeable to or consenting to that. Whatever last year's rates was, we'll pay you that quite happily. Not a problem there. But we're not consenting to these extra fees and charges you've applied by making changes or amendments to the agreement or the contract, which says that we're obligated to pay them.
Yeah.
That contract law expressly prohibits that from occurring.
Yeah, see, Jenny's really up with all that stuff, and she basically covered all that at the meeting. And one guy just didn't speak because he had no idea what he was going to say anyway, the CFO. And the offsider was a lady, and she basically giggles when you mention the Constitution, and she kept bringing up about the 1993 legislation gave council the powers to do all this.
Okay, but that 1993 legislation was passed by the state, and the state has then passed law that is in direct conflict with the highest of Commonwealth law we have, being our Constitution. 109 therefore renders that state law invalid due to its inconsistency with the Constitution itself. Yeah. No state or parliament of the state can make laws that are not subject to the Constitution. And any laws or legislative framework or instrument relied upon granting powers to local council as a legitimate tier of government is in direct conflict and contrary to the Constitution itself, meaning the state laws that they pass to do so are rendered invalid under Commonwealth law.
Right. Okay, so what steps do you think we should take here on? I was going to write to the Ombudsman because honestly, they just...
Well, All we want proof and evidence provided by the council pursuant to the maxim of law, which states
Right.
the burden of proof lies on the one making the claim.
Yeah.
So be very careful, we're not making claims, that we're asking questions. So what you might want to do, and since you're recording, you can go back over this, Kim, is ask questions like, pursuant to the following facts. One, referendums failing to recognise local councils as a third legitimate tier of government. Is there any, what you want to ask them is that, due to the fact that we've had two failed referendums which failed to alter the constitution to recognise local councils as a third tier of government, can the council please provide evidentiary documentation of where its source or head of power is derived from?
Mm-hmm.
Yep. Can the council provide evidentiary documentation that exempts it from being subject to the terms and provisions of the Constitution, which is where the states and the parliaments derive their lawmaking powers from? Is the council aware that they may potentially be in conflict with our Commonwealth law by operating under state legislation, which is in conflict with the Constitution of the Commonwealth of Australia, as verified by Section 109 and two failed referendums? See, we've done that. We've given them the information, Kim, but I've put it in the form of a question.
Yeah.
That's how we have to operate with these guys. We give them the information so they know we know what we're talking about, but we premise it with the form of a question.
Yeah, well, see, they're basically ignoring that and saying, well, you have the right to go to Land Environment Court to appeal this decision. That's their comeback every time.
So, yes, we'd like to take you up on your offer of filing this before the Land Environment Court, where we'll be seeking for the court to make orders for the requested evidence to provide proof of your claim to be provided.
Right, okay.
Yep. And they'll say, under a Local Government and State Planning and Environment Act, this stands. Well, hang on, Your Honour. It's the use of these legislation that is in question. And this is a constitutional and federal matter, not a state matter, because it would appear, we're not saying it is, we're saying it would appear that the states have passed laws granting powers to local councils as a third legitimate tier of government, which is contrary to the Constitution and two failed referendums. I believe 109 applies, which invalidates the state law granting such powers or conferring such powers onto the local councils, considering them to be some form of third legitimate tier of government. The only legitimate tiers of government are state and federal.
Yep.
And then you can ask, if the council is claiming to be a legitimate tier of government, in what capacity is the council operating under? Their executive, legislative or judicial capacity? And can evidentiary documentation be provided? One, that provides proof of claim of their source or head of power and where that authority or power is derived from. And two, if you are a legitimate tier of government, then are you claiming or purporting to operate under the executive, legislative or judicial capacity? And that's a trick-loaded question, Kim. The executive, legislative and judiciary is what's called our separation of powers. The executive cannot interfere with the legislative or judiciary and vice versa. And the separation of powers laws are quite strict. And if they go, our separation of powers laws is horseshit, doesn't apply to us, well, the High Court may think differently due to precedents set in 1956 under the very famous R versus Kirby or Ex parte Boilermakers Association case, which verified the separation of powers laws and the severity of breaching them.
Yep.
We also have our other very famous High Court case law, and you can ask them, can the council please provide a certified copy of the documentation or evidence relied upon that claims the council is exempt from High Court precedents, such as those set in the R versus Kirby case of 56 and of those set in the very famous Queensland Rail case of the 8th of April 2015, where Queensland Rail, in fact, lost that court case because of two sections of our Constitution, being 5120 and 109, both of which were upheld by the High Court. What happened in that case, to explain, Kim, and the council's in the same boat here, Queensland Rail The issue, they'll say, oh, that's got to do with work conditions and the Fair Work Act. Well, no, there was more to it than that. What happened was Queensland Rail was determined that they weren't in fact registered to the state of Queensland because Queensland Rail had an ABN and or an ACN, much like the councils do.
Mm.
According to the High Court, pursuant to 5120 of our Constitution, listed them and identified them as a trading company or corporation, which technically speaking and legally speaking, in accordance with determinations and precedents made by the High Court, registered Queensland Rail under the Corporations Act, which is federal legislation or Commonwealth legislation. Now, it was determined by the High Court in that case that the place of registration is the jurisdiction you come under. And due to the fact that they had an ABN and were listed as a trading company or corporation, they are registered under the Corporations Act, not under state legislation, in which case you're registered under Commonwealth and federal legislation. That's the jurisdiction you can apply, not state. And due to the conflict between the state and federal legislation, 109 was also upheld in that case. And you believe that precedent to be entirely relevant to this matter, pursuant to the fact that the councils all have their own ABNs and their ACNs and are legally and technically speaking supported by High Court precedents registered under the Corporations Act, not to the state. Not to mention that the state's passed legislation not subject to the Constitution in order to grant local councils any form of power or authority or legitimacy as a further third tier of government to which two referendums failed to recognise.
Yep.
I'd like to remind them that our politicians and councillors only have one job, and that job description is to represent the will of we the people, which clearly has not been done.
Yeah, exactly. We put it to them about them having an ABN and that they were functioning as a corporation or
they're a body corporate. They come under the body corporate.
Body corporate.
Yep, not as a legitimate tier of government. And a corporation or body corporate cannot act or masquerade as the government either.
Yeah, and that's another thing we put to them. So, you know, they know where we're coming from, but they're just sort of thinking, well, these pair will just...
Well, Kim, can I ask you, did you include and quote the High Court case law and precedents that I've just given you as well? And the constitutional referencing and sections?
No, not that one, no, because like it was our first meeting with him, like Jenny covered a lot of stuff, what you're talking about, but no, we didn't state any. She did actually mention someone because I remember she mentioned a case because they were being a bit smart about things.
Is the council claiming it's exempt?
Yeah.
From High Court case law and precedents.
Right.
Precedents already been set by the High Court of Australia. And going against a precedent set in the High Court, you tell the council, is well above both your pay grade and mine.
Yeah.
Only the High Court that can overturn decisions or precedents set in the High Court. That is well outside of your scope of power or authority and definitely well above all of our pay grades.
Yeah.
Yep.
One other thing, like instead of having to go to land and environment, like can we get like the ACCC involved or ICAC rather than pay a fortune to go to land environment?
You can do. You can also claim the Free Court Access Act of 1400 and not pay for the courts.
Okay.
Look up Free Court Access 1400. That grants anyone free access to the courts. Because they don't tell us about this as always, Kim, because there's always more options than what's being offered. And they'll say, no, you have to pay, we have to pay. Well, they're not the only options. What about a Free Court Access of 1400? The courts are meant to be accessible for free to anyone. And over time, the courts have become a tool for the rich and the elite to he who pays the most money wins, which is not how they're supposed to work.
Yeah.
Yeah. The magistrate or the arbitrator or judge or whatever position they're holding is meant to do that in a non-biased, impartial manner.
Yeah. Well, that sounds good because I know a lot of people are angry with him because I've been putting it on a website and like there's over 200 or more that have had enough of them too with this category change they've done to us all. But we heard a whisper that that's what it was all about, these smart cities.
And that's what it is, so they can come back and then claim if you're on 10 acres, that's 40 quarter acre blocks we can fit. We're now going to levy, you either sell us your property because we want it, or we're going to adjust your rates to reflect 40 properties that we could put on the same space. And I've done this to other farmers who were put under gag orders as to why I was told about it in confidence, but I've let others know without dropping names. That this is going on. This is how they're going about doing it, to reclaim the land and pushing everyone further and further out into the sticks and the boondocks where they don't care and they're not required to provide services. But it's all about them being able to extend their regional council area, because once the councils get above a certain amount of population in an area, they then get increased funding. And of course, those working for the council all get a pay rise when they go from being a shire to a city.
Yeah.
They need X amount of population for, or at least the zoning approved for. And of course, who approves the zoning? It's all done in-house, isn't it? It's all right, guys, we've investigated ourselves and we've found no wrongdoing. Nothing to see here. Can we get a second opinion or a private investigator? No, there's no need for that. We've investigated ourselves. There's nothing to see here.
Yeah. So you don't think the state government's been pushing it on the council to do these smart cities?
I believe it's probably come from there as well. And I'd be asking for the state government how they pass these legislative acts and instruments that are in direct conflict with our constitution and contrary to High Court case law and precedents. I'd be asking the same of the states. I'd be putting that potentially to an ombudsman.
Yeah.
Ombudsman's a really good one to contact, Kim, because they're usually a toothless tiger.
Yeah.
But it costs them thousands to respond to the ombudsman. It's a free service for us, but whoever the ombudsman contacts gets a bill for thousands of dollars, and they try and resolve things quickly.
Yep. All right. Well, I was going to put a letter together today, especially because they won't answer the questions on regarding the Constitution and the way Jenny does it. She's very good at it because she's learned a lot, and she speaks like you do, like what they're doing is illegal and what do you call, just trying to see, like their biased opinions and, you know, asking to provide evidence and everything. She's done all that and even put it in letter form and they won't answer. And I said to her, well, the ombudsman is very interested in them not answering and they're keen on looking into it.
There's some procedural requirements. And what they'll say is, we responded to your letter. We did answer you, but they didn't answer any of the questions.
Yeah.
Yep. Oh, yes. Thank you for your correspondence. You're a sovereign citizen. Fuck off and we don't care.
Yeah.
You didn't address any of our concerns or answer our questions. But we complied with our legislative requirements by providing a response, even though it was an autoresponder or a cut and paste job. They will claim response, and you'll claim, well, the response was invalid as it didn't address any of our concerns or answer any of our questions.
Yep. Okay. Response invalid.
And that's the thing, when it goes to things like the magistrates or land environment court, you can then ask the court to make orders for the evidence they're relying upon for proof of claim to be provided.
Yep.
That's the beauty of engaging the courts in this, Kim, is you can get a court order saying, well, Your Honour, we're not disputing their claim. We've just asked for proof of.
Yeah, exactly. That's what she did ask, proof of.
And it's like, you know, we're not saying that you're thieving, lying sacks of shit. We're asking you to prove that you're not.
Yeah. Yeah, no. So she's actually done all the correct things. Like I say, she asked all the correct questions, but that letter they did not. And she did the process of first letter, second letter, third and final notice.
Yep.
And I'm pretty sure to that she did not get a response.
Yep. So you might say that's a breach of their duty of care for not responding.
Yeah.
Because the council is, even if they send you back a letter saying screw you, they still need to respond.
Yeah, exactly. Yeah. So, well, it sounds like
Put some of that together with the High Court case law referencing and precedents and ask them if they can provide some sort of certificate of exemption that exempts them from complying with High Court case law and precedents already well established.
Yep.
The highest court of the land that we have being the High Court of Australia.
Yep.
I let them know, look, we're not saying we're not going to pay the rates. What we've done is we conditionally accept your offer on the condition that you provide the evidence which supports your claim. Otherwise, this will be raised as a legal dispute and may go to a court of competent jurisdiction, such as the magistrates of the Land Environment Court, and you may like to take it up with an ombudsman as well.
Yeah. Okay. Sounds good. All right. Now,
we've got to give it a specific legal framework that we're contesting and ask them, how is it they became more equal before the law than the rest of it? And how did they become exempt from our constitution and our federal legislation, which is supposed to protect us from the corrupt states and the parliaments of by passing state legislation, which has not been done subject to the Constitution as specified under the lawmaking powers of the Constitution, courtesy Section 51.
Yep. Okay, I'll get that all looked up. She's got all that information about Section 51 and that.
Yep. So you want Section 51 at the beginning where it says, subject to this Constitution, the states and parliaments of have the power to make laws for the peace and good governance of the states and their people. Section 5020 was upheld in the High Court case of Queensland Rail, identifying any entity with an ABN as a trading corporation, putting them under the Corporations Act, incorrect jurisdiction, as the place of registration is the jurisdiction they come under.
What section was that one for the Queensland Rail?
5120 and 109 were both upheld in that case. So 51XX.
Okay.
Section 51 is a very large section of the Constitution, Kim. There's a lot in there.
Okay, yep. All right, that's good.
So what we can do is you can say, pursuant to the following, can the council please provide evidence to the contrary of what we've just stated? So again, give them the information, but finish it with a question.
Yes. Yep. Okay, we'll definitely follow that up then. And I'll get in contact with the Ombudsman too.
Yeah.
Because we've just been holding off on that to see which way we should be going.
Yeah, definitely speak with the Ombudsman and get them to chase that up over their authority to levy rates and ask them where is their source or head of power or authority derived from.
Yeah. Yeah, because I've just found the letter that Jenny wrote about. I have requested on 3 occasions the answer to my questions regarding the jurisdiction under the law that council is operating for the alleged authority under law and a few other questions, but they never returned any information on that letter. Like that was one of her letters.
Yeah.
So, okay, well, at least we've done the correct thing in what you say.
You're doing, Kim, conditional acceptance.
Yeah.
Yep.
Yep.
Not disputing your claims, guys. We just want you to provide proof of, and we're happy to settle the bill.
Yeah. Yep. Okay.
Yep. Very polite response. I've got to run because I'm back to back today, Kim.
Well, my son just wanted to ask one question. If you've just got a second,
Yep.
didn't you want to ask about
UCC?
Yeah.
Oh yeah. No, I'm saying I've got no. Zev, how you going? I've been sitting here listening. Yeah, no, I'm gonna book an appointment in for the UCC. I'm up to that stage.
All right.
Yeah, I was just telling Mum about it before. But no, that's all good. I really appreciate all that help. Mum's gonna use all these notes and yeah, we'll get on to that. Thanks for your help.
That's all right, mate. Stay on your computer for 5. Yeah. Because when I get off the meeting, it'll say converting to MP4.
Okay.
Make sure to rename the file. Zoom has a really annoying habit of naming the file with some random numerical number, and then it will save it in some random location. You'll never find it. So I'm going to jump off the meeting, stay online, and just let it convert to MP4, and then rename it and save it somewhere where you can go back over it and get some better notes from it, Kim.
Okay, thank you. Appreciate your help.
Awesome, Zev. Thank you.
Get a response from the council after you put this together. Please send it through to me and let me know.
Okay, no worries.
Awesome. Thanks, mate.
Thank you.
Take care.